Welcome, everyone. My name is Tom Hecht. I'm a partner here at Nixon Peabody, and on behalf of Nixon Peabody and the other sponsors of tonight's forum, Hughes Sokol, Piers Resnick and Dim, the American Constitution Society, and the Cook County Bar Association, we welcome you and hope we have an interesting and challenging forum this evening. It's a privilege for us at Nixon Peabody to be hosting this event. We have a wonderful group of candidates who are in front of you and will be the forum. It's an extraordinary group. And because of that, this is really an extraordinary occasion. And we at Nixon Peabody and the rest of the sponsors as well are extremely pleased to be hosting this event. As you can see from the setup here, CAN TV, C-A-N-TV, is cable casting and streaming the proceedings as well. So be on your best behavior. I'm not going to speak at all any more than that. I'm going to turn it over to Chris Wilmes of Hughes Sokol, who is going to be the moderator for this evening. Chris.
Thanks, Tom, and thanks to the ACS for asking me to moderate the event tonight. We thank all of our candidates for being a part of this evening and appreciate your time and to let us know more about your qualifications to be an Illinois Supreme Court Justice and your views on judging. So I think that the format today, I'd like to ask a few questions that apply to all of the candidates, and then I've got a couple of individual questions that I'll direct to each of you. And I think just to start off, we'd like to invite everybody just to take 2 minutes. Please try to be respectful of the time limits because we got to stop at 7 o'clock. If you could just take 2 minutes and we'll let you provide an opening statement just explaining why you think you should be elected to the Illinois Supreme Court. We'll start over here with Justice House and move around the table.
Good evening, ladies and gentlemen. I'm grateful for this opportunity to present my credentials to you for the Illinois Supreme Court. I want to thank Nixon Peabody, the American Constitutional Society, and others for giving me this chance. The most important job of the Illinois Supreme Court is to protect the civil rights of every individual. We need justices on the Supreme Court who believe in liberty and justice for all. I believe in protecting the civil rights of every individual, regardless of race, gender, religion, ethnic background, or gender identity. I believe in fairness. We as judges can't tell you how we're going to vote on matters, but we can tell you our values. I believe that we as a country have to do more to protect the most vulnerable of us in society, and that's why I'm running for the Supreme Court. To truly serve the most vulnerable people in our society, you must have a perspective for that society, for those vulnerable people. And I have a perspective that protects the underdog. I was born an underdog in the state of Tennessee in a small town of Murfreesboro. I attended segregated schools. My family and I were subject to Jim Crow laws, which promoted the unequal application of justice. My dad had a master's degree in political science, but the best job he could get was night shift in a bomb factory. We became part of the Great Migration, became Chicago. In Chicago, both my parents worked full-time. My mother's a teacher. My father is a post office, at the post office initially, and then for the city of Chicago. But while working for the city, he decided to become a lawyer, so while working full-time, he took law school classes at night. On many weekends, my brother and I would sit at the kitchen table across from each other doing our homework. And then we could look at the dining room and see my dad with his law books. So I learned those lessons when I saw his tireless work and devotion. I decided to become a lawyer, and I followed his footsteps. I practiced law for 22 years. I served as a judge in Circuit Court of Cook County. And I brought the lessons of diligence with me to the court. The court appreciates my emphasis on work ethic. I found I have reduced the backlog in 6-month-old cases to almost zero as a result of my serving as the executive chair. I promise you and all the voters of Illinois that I will work as hard as I can every day as a candidate and a Supreme Court Justice on behalf of underdogs. So if you believe that my perspective as a Supreme Court will benefit your communities, I ask you to remember 5 little words: house is in the house. Thank you.
Mr. Kisloff?
I want to thank you all for coming, and thank you for sponsoring this, and thank you for conducting it. All of us will tell you that we believe in equality before the law. All of us believe in fighting, doing what we can to improve the justice system. I've spent the last 40 years of my practice fighting injustices wherever they lurk, whether it's on behalf of people charged an ethnic hair charge, extra for being black, whether it's pensioners who were having their benefits cut, sliced, whether it's people who cast absentee ballots that were challenged and they weren't notified of their disqualification until about 3 months after the election had occurred. I spent the last 40 years fighting injustices wherever it lurks, and it knows no particular ethnicity. It applies to all. And so, one thing that I think you might ask, all of us, and everyone will tell you they will try to make the justice system better than it is now. Ask them each what they've done so far to make a change in that system. What has changed because they've been there? And you can judge, I think, by what they've done as to what they're likely to do in the future. I'm proud to run on the record of what we've battled for and will continue to battle for. We'd like to make the system much more open and transparent. We think that all of my colleagues here should have more oral arguments, hearings, because the perception of justice is almost as important as the actuality. But if people don't think that they've been heard, then the perception, the legitimacy of our court system is in great peril. I've voiced complaints about how the system works and offered improvements, and I'll be glad over the next hour to answer those questions. I think I bring a unique background of having fought injustice and practiced before some of my colleagues here. Whether they've been with me or against me, ruled for me or against me, I'm glad to run on my record, and I hope that you'll agree.
Justice Reyes.
Thank you. I'm Justice Reyes, and I'm running for the Illinois Supreme Court, and I want to thank the American Constitution Society, as well as Nixon Peabody and Hughes Sokol for this opportunity to be here, and I want to thank everybody else in the room who is attending this debate. I come from a blue-collar neighborhood. I was the son of immigrants, and I didn't have a lot of opportunities growing up, but I was able to succeed, as the American dream is, to reach to the appellate court in Illinois, and I've decided throughout my career to always make sure that I give back to the community, and to make sure that I can help the community. But one of the ways, and one of the best ways I thought that would be, is to serve as a judge, as a public servant, to give back to the public. And I believe that in public service, it's not about just doing it while you're on the bench or in the robe, but it's when you're off the bench as well. I believe in being a public servant 24/7, and I believe in making sure that the justice that we render is not only done in the courtrooms, but outside the courtrooms. And that's why I've become very active and involved in the various communities, establish foundations to help those who are marginalized and economically disadvantaged, because I think they are also in situations where they want to aspire to obtain their dreams and goals. And I want to make sure that I do that. And that's part of what I'm going to bring to the Illinois Supreme Court. Also, I've had a reputation on the court of when I see something, I try to fix it, try to correct it. And that is also what I'm going to bring to the Illinois Supreme Court. So I'm going to ask for the viewers and for those of you in this room that come March 17, 2020, you give me your serious consideration. Thank you.
Justice Cobbs.
Good evening. I think I can be heard. Is this on or not? Yes. It's on. Good evening. I am Cynthia Cobbs, and I am a justice currently serving on the Illinois Appellate Court. In short, I am running to be a justice on the Supreme Court of Illinois because I believe that I bring the qualifications and the experience that are necessary to add value to the work of the Supreme Court. The work of our Supreme Court is to ensure that justice in the state at every level of our court system is administered fairly. I grew up in the state of Maryland. I received my undergraduate training in Maryland. I went to a historically black college, Morgan State College. I received my master's degree in clinical social work from the University of Maryland. I then married a pretty tall and handsome guy, and we relocated here to the state of Illinois, where I received my law degree from Chicago-Kent College of Law. I was not raised in a family of lawyers. There were no lawyers on the street where I was raised. There were no judges on the street where I was raised. In fact, my first encounter ever with the judge was when I was representing a child in a child protective matter in a courtroom in Maryland. It was my work as a clinical social worker to present to judges in the state issues related to the child protection arena. Many times in those courtrooms, I would find that the judges were not necessarily cognizant or aware or knowledgeable about child protection issues, about developmental stages of children, what children could perhaps fabricate and not. So I thought maybe I would approach the protection of children from another aspect, that being law. So in 1988, I was graduated from the Chicago-Kent College of Law. I, like many of my college peers, law college peers, applied to many law firms. I was rejected by most of them. I was not rejected by the Appellate Court of Illinois, which is where I got my first training in the court system and where I remain to this day. I have served at probably every level of the Illinois court system that exists. I started out as an appellate court research attorney. I was
wrap it up,
invited
Justice
by
Capps.
Justice
Just
Freeman.
2 minutes, please.
Oh, I'm sorry. And now I currently serve as the appellate court justice. Hard to squeeze it all in. In any case, I'm hoping that my experience and my qualifications, once you review them, will convince you and persuade you that I am the most qualified to serve as a justice on the Supreme Court of Illinois. Thank you.
Good afternoon, everyone. My name is Margaret McBride, and I'm a candidate for the Illinois Supreme Court. I'm basically running on my experience and record. It's hard to squeeze in all of our lives in a couple of minutes. I've been a lawyer and a judge for about 43 years. I was a trial lawyer for 10 and a half. I was with a civil firm. I was with the State's Attorney's Office. I became an associate judge in 1987. I served in 5 of the major divisions of the circuit court before I ever went to the appellate court. I was in the First Municipal, I was in the criminal division, I was in the law division, I was in the chancery division, I was named the presiding judge of the Rolling Meadows Courthouse, where I supervised about 19 judges and a staff of 20 people. But that experience doesn't mean much unless it's backed up with quality. And so during the course of those 12 or so years that I was in the trial courts, I heard thousands of cases involving thousands of citizens of our state. And universally, I have been found to be fair, impartial, independent, hardworking, knowledge of the law, all the things that we traditionally want for judges. I then ran for the appellate court. I've been there for 20 years. I've participated in probably 6,000 appeals. I have been the author of over 2,000 decisions, but in the appellate court, remember, we all work together. There's 3 of us on every case. But outside the courthouse, I have taught trial advocacy and professionalism for over 35 years. All volunteer time. I've never been a paid professor of law. I've spent those hours teaching others how to be a good lawyer, but be professional. And what that means is respecting everyone. And that's what the justice system is all about. I've been fair. I will continue to be fair. I think it's the hallmark of our system. Justice is not for some, it's for everyone. And I believe that qualifications and experience matter. And that's why I'm running for the Illinois Supreme Court. And I will continue to be fair, impartial, independent, and I believe a good justice for our state. Thank you for having this forum today. It would be good if there were more forums like this with larger groups of people that could hear all of us speak to our qualifications. So thank you.
Justice Neville.
Good evening. I'd like to begin by thanking Nixon Peabody and the American Constitution Society.
What about Hugh
My name
Sokol?
is- Pardon?
What about Hugh Sokol? You know, come on, throw us a little bone here, Justice Sokol.
And
We're on the panel. We're on the
moderator
thing there too. I'm just joking with you. Go ahead.
But I would thank you at the end. At any rate, the Illinois Supreme Court has been in existence for some 200 years. In fact, last year was its bicentennial year. I became the 117th justice and the second African American to sit on the Illinois Supreme Court in its 200-year history. But I was born in the city of Chicago. I was educated in Chicago's public schools. I've lived most of my adult life in Bronzeville. Some people refer to it as the ghetto, but I refer to it as sacred ground. During my 45-year legal career, I have been on the battlefield for the poor, the oppressed, the downtrodden, the left out. One of my colleagues said, it's not what people plan to do, it's what they have done, and I agree with him. Well, let's begin in 1998. I was one of the lawyers for the legislators that promulgated the sub-circuit legislation. Let's jump to 1998. I was one of the co-founders of the Alliance of Bar Associations. On the Illinois Supreme Court, I have fought to see that no person is unseen and no person is unheard. In fact, I have made one landmark decision, People versus Buffer, that will permit 128 juveniles who had a sentence which exceeded 40 years imposed upon them to have their sentences reconsidered. I will leave it to Cook County's voters to decide if they want a Supreme Court justice who fights to see that litigants get the justice they can afford or the justice they deserve. I am asking you for your vote. I would hope that you would help me keep the seat. Thank you.
Mr. Epstein.
Thank you. Thank you all so much. My name is Daniel Epstein. I'm running for Illinois Supreme Court, and I'm running to bring about systemic reform to protect our courts and our communities from bias and from corruption. The Illinois Supreme Court is the highest court in the state. It decides the biggest cases in the state. That's what it does do. But what it can do is much, much bigger. Because the Illinois Supreme Court writes the rules of procedure, of evidence, of ethics. It determines things like design standards for our courthouses, which have an impact on access to justice for undocumented people and people with disabilities and trans people and people with caretaker responsibilities and people with jobs. It has a role to play in the data infrastructure of the court, in determining who gets to be a lawyer and how in attorney discipline, and on and on and on. The Illinois Supreme Court is like the chief executive of the justice system. And in those areas, there's much that we can do. The Illinois Supreme Court is a policy-making body. It decides cases, but it also makes policies that dictate how our courts work. Right now, we know that as a policy-making body, it has the power to prevent injustices that exist in our community. We know that there are people who have been deemed safe to return to the community, who are presumed innocent, but who linger in jail for years because they don't have enough cash to afford bail. We know that our courts are vulnerable to conflicts of interest and judicial corruption. We know that we are vulnerable to racist jury selection and biased sentencing. On all of these issues, there is much that we can do, but we're tragically silent. We don't have the moral right to remain silent on these issues. I'm running to bring about systemic reform to protect courts and communities from bias and corruption. Thank you.
So, let's stay on that topic, and we'll just do another 2 minutes to answer this question, which along those lines, Mr. Epstein, I'd like you to just, pick one rule, one Illinois Supreme Court rule that you think is most important either to pass, revise, or remove. Just one. Give each candidate a couple of minutes to discuss the Illinois Supreme Court rules.
Yeah. So I think number one, we need to provide depositions in criminal cases by right. Even if we start very small, one evidentiary deposition in criminal cases. Right? Right now, there is much that we don't learn in cases until we get to trial. But so few cases in our criminal courts get to trial. In 2017, 97.4% of felony convictions ended in a guilty plea. That means that in 97.4% of cases, we are losing the opportunity to cross-examine. We're losing the opportunity to impeach. In many cases, not in all of them, but in many of those cases, we're losing those opportunities. And that's an opportunity to learn about things that are going on in our society. Our courts have kind of become resolution factories. We're pushing everything to resolution faster, 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 more efficient. And we've lost sight of their role as an information factory. We've created this conveyor belt system of justice that pushes everything to resolution. We're cutting corners to cut costs, and it's one of the most expensive things that we've ever done. In terms of dollars, when we pay hundreds of millions in civil rights claims down the road because we fail to expose pattern misconduct.
Would an indigent defendant have the cost of the transcripts paid for by the state under this rule?
So I think it would certainly be worth it if they were. I think one of the objections has been this will be too expensive, right? By the way, we already do this in civil cases, right? We do depositions in civil cases, and oftentimes the cost is borne by the civil litigants, right? But that's not to say that we're not paying the price for not doing depositions in criminal cases when liberty is on the line. We're paying it. We're just paying it later in civil rights claims. So I think we would still be well advised to foot the bill for even a single evidentiary deposition in criminal cases. There's much that we can learn. There's much that we can expose and protect ourselves from. And we're paying the cost right now in dollars, in liberty, when innocent people go to prison, and in justice to oppressed communities. Thank you.
Very good. Justice Neville, about the Illinois Supreme Court rules, how could they be changed?
Well, I think that there are two very important rules that I'd like to comment on, and those are Supreme Court Rules 301 and 303. Those are the rules that give civil litigants the right to appeal their cases. It's not a meaningful right for this reason. I've discovered that over 70 or 80% of all civil litigants are self-represented. That means two things. One, they probably can't afford to hire a lawyer. And secondly, to comment on Mr. Epstein's point, they can't afford a transcript. I do want to point out to Mr. Epstein that in criminal cases, criminal defendants do get a free transcript. That is not the case in civil cases. My proposal is to permit or put recording devices in all civil courtrooms. I've discovered that there are approximately 400 civil courtrooms in the state. I also know that it would cost approximately $5,000 to put recording devices in those courtrooms. I am pleased to report that on June 15th of 2018, when I was sworn in, I made this proposal, and the eviction courtrooms in the Daly Center now have recording devices. But that's just part of the problem. We all talk about being concerned about the poor and the oppressed. I have another proposal to make, and that is I've been talking to my colleagues on the Illinois Supreme Court about giving CLE, continuing legal education, credit to lawyers who represent self-represented litigants. That would be a way to solve the problem. That would assist litigants who cannot afford to pay for a lawyer to effectuate their rights. If we put the lawyers together with the recording devices and the cheaper transcripts, I think people would have a meaningful right to appeal.
Yeah, but then we wouldn't be able to go to all those CLE classes in June and to fulfill our 30 hours, which we're dying to do that.
I'm glad that you raised that question. That's precisely why the Supreme Court hasn't approved it yet. But I'm only talking about 3 credits for each of the 2 years, for a total of 6.
Can you bump that up to 10? Come on, we're so sick of those CLE classes.
I can't get them to agree to 6,
Okay.
but I'm working on it.
Justice McBride, what Supreme Court rule needs changed or needs to be adopted?
Well, I'm not going to recommend a specific rule change, but I can comment that I've been on the Rules Committee for several years, and when anyone, any person, any lawyer, any individual wants to change a law, a Supreme Court rule, they can petition, they file a request, and the Rules Committee entertains changes to the rules every single year. We have multiple meetings, but just briefly, right now, I'm on the Supreme Court Access to Justice Committee, and we're trying to address a serious backlog problem that we have in the appellate court, not with the judges and their cases, but the state appellate defender, who is the understaffed, and there's a serious backlog. But right now, there are those that already propose that the legislation we have in place allows for transcripts for any individual who is self-represented. There's a statute in place right now that allows for any legal aid society that represents a party for free, that they are entitled to transcripts. So there are some that already believe that transcripts should be provided and are allowed for under our current statutes. As far as depositions, that's something that anyone could propose, but as Justice Neville pointed out, in criminal cases, discovery is conducted for months, sometimes a year. Everything that anyone asks for generally is given, except for the fact that we don't have depositions in criminal cases. But in terms of access to justice, I agree that we should have the availability of transcripts for people that have chosen not to have their own lawyers. And there are ways to do that. And one other thing that I
trial
would recommend,
transcripts or deposition transcripts?
No, I'm talking about for self-represented persons.
Just
that they be
trial
allowed to-
transcripts or deposition transcripts? It's a big difference.
The transcripts for their case, their particular civil case that they are appealing. I'm
Right,
talking
but the
about
depositions. I mean, it's
No,
one
I'm
thing.
not. No, I'm not
Just
suggesting.
just the trial transcripts.
I'm suggesting that there are those that already believe that the record of proceedings that took place in the trial court are available or should be available now without having recording devices.
Very good, thank you. Justice Cobb?
Well, I would probably echo Justice Neville's concern or interest in 301 and 303, and I'm going to tag that on to Rule 711. So essentially, there are an increasing numbers of pro se litigants who appear in our courts at every level, at the trial court level certainly, and even at the appellate court level, and we see them every day. And in many, many cases, these individuals are not successful either at the trial court level and certainly at the appellate court level, because they've not adequately preserved the record, or they will not have a bystander's report. So this raises an access to justice issue for me. I believe that every litigant who is seeking to have their matter heard at any level of our court system, the trial, the appellate, or the Supreme Court level, should have certain guidance that is available to them such that they do not stumble simply on procedural matters. There are currently in many of our trial courts help desks. Needless to say, those help desks are not uniformly staffed, nor do they have necessarily all of the materials or the resources that are required to help individuals who might come into the system. I would support and suggest to the Supreme Court that they could amend Rule 711. Rule 711 is the rule that permits the director of the Illinois courts, which I was for 9.5 years, to license law students for the limited practice of law under the supervision of a licensed attorney. As a part of that 711 license, they could be required to devote a percentage of their time to serving on the help desk at every level of our court system. So if someone came into the trial court, they were not able to afford the services of an attorney, but they had a breach of contract case. In order that that case not be summarily dismissed under either 2615 or 2619, that help desk law student could assist in the drafting of an appropriate pleading that would survive a motion to dismiss. The same thing could happen at the appellate court level to make certain that the filing occurs in time, that there is a record of proceeding, even if it's a bystander's report. I agree that there should be a record of proceedings. As the director of the Illinois courts, we outfitted many of our trial courts with electronic recording devices. It is a costly matter, which was simply born out of the resources by the Supreme Court. The counties were not charged, but what we need to understand is that the circuit courts, the trial court buildings, are buildings that are owned by the counties, not by the state. And so while it seems like it might be practical and easy, the Supreme Court may not mandate to the counties that they allow certain infrastructure changes, and it does take some intergovernmental relations and contracting to get it done. So that's my suggestion.
Thank you. Justice Reyes.
Keeping with the theme about access to justice, I won't deviate at this point in time, but I would take a different tack. And I think what we need to do is provide information to the public, particularly those that are economically disadvantaged and marginalized. I mean, they come to court, they don't know what to do, where to go. So I think we need to provide public information. We need to make sure that they're aware of their rights and the consequences sometimes of going into court. When I was in traffic court, one of the things that I noticed was that there was a disparity in terms of people coming into the courtroom, in terms of who were being charged with DUIs. I brought that to the attention of the chief judge at the time, who was Don O'Connell, and the supervising judge of the traffic court. We went to the police department, we talked to them about this particular problem. They indicated that there was no profiling. So we decided to change the tack, and we decided to put out informational DVDs to the public, particularly to these segments of the population that were being affected, and provide them with information about their rights when they go to court and the consequences of driving under the influence. And, while that system was still in place, the numbers did drop in terms of the people that were coming into the courtrooms. And I think that's just an example of what we should do in terms of providing information to the public, making them aware of their rights and the consequences sometimes of things that they violate the law.
Okay. Mr. Krislov, do you have an Illinois Supreme Court rule that you could propose to modify or?
Sure.
Okay.
352, oral argument, drives me crazy. I mentioned it before.
Sorry, 352, and what's the other one?
The other one is Rule 23.
Okay.
State Rule 23.
That's an important one.
352 on oral argument. The appellate court, I looked yesterday in the law bulletin, and each of the divisions has scheduled one hearing a week. For the next 3 months, there's, I think, one day that one division is holding 2 hearings, and one division that on one day in the next 3 months holding 3 hearings. People need to feel that their arguments have been heard. Rule 352 says where it's requested, you're supposed to grant it. And if you don't grant it, the propensity of our appellate court right now to issue opinions without oral argument leaves them without the legitimacy that the people feeling that their arguments have been heard are needed. The other part of this is Rule 23. The called the U opinions for it used to be called unpublished. When I created this thing at Kent called the Center for Open Government, we took issue with that because the whole idea that you can cite the aphorisms of Miss Piggy and Kermit and Mr. Rogers, as valid as they are, to a court, but cannot cite the hopefully learned opinion of one of 3 justices is nuts. It has gone out of the system in the federal system. It's been abolished by most of the states. It needs to be abolished in Illinois because, and the number of U decisions that come out, they come out at the rate of about 100 a month. And there's somebody weighing in on something. There is a suspicion at times that people want to do it because the concept of U decisions, you cannot cite them except between the parties. It makes no sense. You should be able to cite an opinion, its validity, its invalidity, in any event.
Okay.
Those two things combined, where the appellate court renders a decision by a U decision without oral argument, so eviscerates the perceived legitimacy of the decision, that it leaves the parties thinking it's a rigged inside system.
Okay.
That transparency, we helped start down the road of opening it at the Center for Open Government Law Clinic vote that we would get rid of the Rule 23 prohibition, and that colleagues here all grant at least, if you're gonna schedule oral arguments in a day, fill up the day with them. Do 6, do 8, it'll just take up the day, but the litigants will feel like somebody listened to them.
Okay, thank you, Mr. Krisloff.
Litigants will talk.
Thank you. Okay, Justice House, Supreme Court rule. Can you talk about how you believe it'd be advisable to amend the Illinois Supreme Court rules?
Well, I've always believed that justice denied is justice delayed is justice denied. And one of the things that I worked on when I was chair of the executive committee of the appellate court was that I promulgated a rule that if a case was ready for 6 months or longer, that is, all the lawyers have submitted all their arguments, the oral arguments have been done, the briefs have been submitted, that any judge who had a case that was older than 6 months would have to write a report to the executive committee explaining why that case had not been resolved and what we could do to help them resolve it.
Is that report then made public to the?
No, it's not. It's kept in.
That's what they do in federal court.
But
You get the shame list. You don't want to make it public?
Well, you know what? It worked so well that the number of cases 6 months older or older has dropped to almost nil in the appellate court. And I'm a person who's always looking to help the court system and look for better ideas. That would be a new rule that I would propagate for the entire state. That when you have the appellate decision waiting, all arguments have been done, then we have to write a report, and that would result in a reduction in the number of backlogging cases.
How about the circuit court judges too?
Well,
They have a fully brief motion for 6 months. Would
well,
you be in favor of that as well?
That would have to be addressed as well. And when I hear other complaints from lawyers, one of the other complaints that I hear that needs to be taken a look at is that the arbitration maximums. For example, we need to raise the limit for mandatory arbitration to $100,000 to help the municipal division dispose of their cases as well.
You want to put more mandatory arbitrations?
Yes.
What do you think about that, Mr. Krisloff?
I'm against it.
Okay. All right.
I understand the desire.
Yeah.
Can you use the microphone?
Experience with arbitration.
Use the mic.
Oh, sorry.
Oh.
I understand the desire for court efficiency, but my experience certainly in consumer cases and in most of the other cases, arbitration works where there's an evenness of resources. But we have a case against a big car rental agency that was charging people a concession fee at the downtown location, which I understand is not an airport. And that adds 10% to everybody's rental to recover a concession fee that doesn't exist. And we're forced into arbitration, and we think maybe we have a way out of that. Arbitration is great where there are two parties and you can negotiate between them. Arbitration otherwise is channeling people with unequal resources into a bad situation.
All right. I want to make sure that we have our fair and let everybody else get their points in today. So I want to move on, and the next question for each candidate, and I think that this should be a relatively short answer. I'd appreciate it if you could just try to keep it to a minute. Is how will you ensure your independence in light of campaign donors? Will you recuse yourself from a case if a large donor appears before the Illinois Supreme Court in one of the cases? We'll start over here, Justice House. Would you recuse yourself?
Well, I make it a point not to look at my B2 statements to see exactly who and what amount is being donated. I do attend my events and I know who's there, so I do have some idea that they're present. But I do know who's chair of my finance committee, and I would recuse with that individual had a case pending before me. I've been a judge now for almost 21 years, and I have been able to separate my sense of fairness and justice from. I've insulated that from any donations, and I think I will continue to do that. I think I have a reputation for being fair, and I think that I'll be successful in doing that in this race as well.
Okay, Mr. Krisloff, would you recuse yourself if a large donor appeared before you in the Illinois Supreme Court?
I would be surprised if there was a large donor who appeared before. I don't see that as a problem. I don't.
Well,
But
let's
the
just say
answer is-
hypothetically speaking that,
The
I
answer-
wrote you a check,
The
Nixon
answer-
Peabody wrote you a check for $100,000
And I got it.
and told you, good luck on the campaign tomorrow. If Nixon Peabody had a case before you, would you recuse yourself?
I would. One of the problems, though, in the Illinois Supreme Court is there are only 7 justices. And in some cases, like if you represent all the city employees and there are people who are city retirees or relatives, it becomes a problem. And that's something that the court has to figure out how to deal with. But in the case of your donor, obviously, I would recuse.
Okay. How about you, Justice Reyes?
I would recuse as well, and then I would also include in-kind donations that would come in, through our campaign.
So I, like Justice House, never look at a D2. I really don't know who is contributing. I see who is at fundraisers, and I might make the inference that they also contributed. We have a responsibility to avoid even the appearance of impropriety. And to the extent that my participation in a case might create a perception that I have no ability to be impartial, then yes, I would recuse myself.
Justice McBride?
Well, first of all, there's absolutely no question that I would recuse myself. And over the past several months that I've been running for the Supreme Court, I would always recuse myself for if one of the chairs that I had is involved in a case. But I have a large committee, and it's really unfortunate that judges actually have to raise money to run for office because most oftentimes the people that know us best are lawyers that appear in front of us. And unlike my colleagues that say they don't look at anything regarding who's donating to their campaign, I believe that it is absolutely imperative that you know who are the individuals contributing to your campaign, because you shouldn't be hearing their cases while you're running. And if you don't know who's contributing to your campaign, then you could be hearing a case and the other side wouldn't even know that there's a large or some kind of donation to your committee. So I personally think that you should know who is contributing so that you can recuse yourself. And I recuse myself on any case where I think that the other side would be at a disadvantage, because if someone has given you money and you're hearing their case and the other side doesn't know about it and you rule against them, what does that look like? That is the appearance of impropriety. So I'm sorry, but that is the way I do it. I will continue to do that. And if I get a donation, I'm not going to hear the case, at least not while I'm running for this office.
Justice Neville?
Well, I sit on the Supreme Court. If there was an appearance of impropriety, I certainly would recuse myself. Since I've been on the court for a year and 4 months, but who's counting, I've recused myself on a number of cases that came up from the appellate court where I simply decided a motion. And I think in order for people to have confidence in the system, if somebody raises an issue, it's best for the court system that the judge recuse himself or herself.
Well, what about the hypothetical that I gave, right? I mean, law firm donates $50,000 to your campaign, and then 6 months after the election, they're a litigant in your case. Would you recuse in that circumstance?
Well, as has been pointed out, I'm not paying particular attention to the D2s. As recently as a couple of days ago, those things were filed. I have a committee, they took care of that. If somebody raised the issue, if I was unaware of it and brought it to my attention, then I would certainly recuse.
Okay.
You should also be advised that I go so far as to even avoid many times looking at the lawyers who are involved in the case. On the PLAs, I often don't even look at the judges who are making the decision. I just address the issue and make a decision.
Okay. Mr. Epstein, large donor, makes a donation. You're elected to Illinois Supreme Court Justice. Large donation to your campaign. Do you recuse?
So anecdotal assurances of fairness are insufficient. We need structural assurances of fairness. To allow people with alleged conflicts to determine their own conflicts is a conflict. right? It's something that we don't allow at law firms. We have a conflicts department, and we should have that in our courts as well, in our appellate and Supreme Courts. That's what I would do, and I would, in the meantime, before we get that put in, I would pre-commit to having an independent person determine any alleged conflicts.
Okay. The next question is about appointment of circuit court lawyers to circuit court vacancies. So I'd like to ask each of you, what are the criteria that you will use to appoint lawyers to circuit court vacancies? Go ahead, Mr. Epstein, you can start again.
So community input is really key. I think people should have the right to provide input on who the people are who are going to be judging them. That's a big, important part. I think it's important that the people that we appoint have experience not just in Illinois, but outside of Illinois as well. I would create a committee of attorneys and others to help me select someone to appoint, and I would consider that. But my view is that
what are the criteria besides the community? Right. What are you looking for in terms of experience, or maybe you're not looking for experience?
Right. So I am looking for experience. It's not all jury trial experience, which I think we put a lot of weight on currently. There are a lot of stages of litigation, of modern litigation, that aren't exactly in that one bucket. So I think it would be important to look at getting folks who have experience with e-discovery, right, which is a huge part of modern litigation, but is really diminished in the view of many who do qualifications, right? So I'm looking at legal practice from a more holistic standpoint, and looking not just at jury trial experience, but experience with appeals and discovery and pleadings and all across. And also in terms of scholarship, I think all of those things are important, combined with community input and experience outside of Illinois, so that people have a range of perspective.
Okay, thank you. Justice Novell, what are the criteria that you're looking for in somebody you're going to be appointing to the circuit court bench?
Well, I'm the person sitting at the table who's had an opportunity to appoint 9 people to the circuit court. The first thing I looked at was experience, minimum of 12 years, 10 to 12 years of experience. I want a broad-based type of experience, criminal and some civil. It would also be very helpful to have some appellate experience. I do think that it's very important for lawyers to appear before the bar associations to be evaluated. Of course, I was the co-founder of the Alliance of Bar Associations, and I have a lot of confidence in the evaluations they provide and the information they provide to the court. I think that the associate judge process has been a very good barometer for me to use. I have looked at the things that Judge Evans has done, and I've looked at the evaluations he's given to candidates. He has a committee, so I consider that to be my surrogate committee acting for me. I've always been concerned about having my own committee. I would think that I could pretty much dictate what they do. I would like to think that it's better to let some independent group conduct the initial round of evaluations. If I feel an evaluation is unfair, I have a committee that acts as an appellate court.
Very good. Justice McBride.
Well, first of all, I would definitely have a committee. And the first things that I would look at in any candidate are their qualifications. And by that, I mean, what are the qualities that make a good judge? And basically, they are having some experience as a lawyer. I think Justice Neville has indicated 12 years. That's kind of the standard that the bar associations and the Alliance use, so that someone who's had some experience practicing law, that's kind of a basic. But then we look to whether or not the person can be fair. Will they be impartial? Are they going to be neutral? Are they going to hear cases and decide them fairly, so that every single person that is before that judge is going to get a fair hearing? They have to have knowledge of the law. They have to have integrity. They have to have honesty. They have to be decent, hardworking people, willing to put in a full day's work for the administration of justice. So yes, I would have a committee. I went through the associate judge process 3 times. I've promised the bar associations that I will not only have community involvement, I want diversity and inclusion, and I want people that are willing to tell me that they're going to be fair, impartial, they're going to act with respect to everybody, have a good temperament. How we treat people in court is so important. So
you.
I think that qualifications matter for committee. And this is the other thing. The
We gotta wrap
process
this
of
one up,
appointing
Justice McBride.
judges has never been open and transparent. When there's a vacancy in the Supreme Court now, there are notices and you can apply for the job. That should be throughout the courts, for the appellate court, for every circuit court, for when there's a Supreme Court vacancy. Everyone should be able to apply and meet the qualifications and then make a decision so that it's open and transparent. So I would change the way that appointments are made.
Justice Cobbs, what qualifications are you looking for in somebody you appoint to the circuit court bench?
So my basic qualifications would be legal competence and experience. Not necessarily having tried 1,000 trials, but legal competence and experience. As you know, I come from a different background. My background has been 31 years working in the court system, reviewing litigation. And so I kind of yield or lean to legal experience and competence in a broader sense. I would also look for community involvement because I believe that being a judge requires that you be engaged and involved in the communities that you serve, not that you can simply find the law and apply the law. Every good lawyer, every good judge can do that. Additionally, I would look for a solid and a good reputation among the bench and bar for anyone who is seeking to be appointed to a judgeship. And then finally, I would look for a strong work ethic. That's important to me because I think that if it's 9 to 5 to you from Monday to Friday, that's not exactly the strongest work ethic that I think you should bring to the bench.
Thank you. Justice Reyes, what are you looking for in the people that you appoint to the circuit court bench?
Well, I think it's important that the people be aware of who sits in their court, the people's court. So number one, I would make the process public. I would let the people know, who I'm looking at in terms of potential candidates. Look at diversity, definitely for sure. Experience, education, demeanor, temperament. I think those are important characteristics also that we need to have in judges that sit in the courtrooms. Many times we hear this term robitis. These people get into the courtroom and then they become a king or queen of the courtroom, and I think that does an injustice to the citizens and to the members of the state. So I definitely would look at temperament and demeanor, and then with regards to the committee, if I would establish a committee, I'd make sure I had lawyers on there, retired judges, and lay individuals as well to make the determination and evaluation of sits in those courtrooms.
Thank you. Mr. Krislov?
I agree that the process ought to be open, transparent. I agree that the person has to have competence, and I agree you ought to be able to see who's applying and open it up for input. I can repeat most of the things that I've heard said, but we'll see who applies. We'll see what strengths they bring, and we want diversity of experience. We want diversity of community. We want great lawyers who want to become great judges. And to embellish on that, I think we'll just repeat what my colleagues have said.
When I appoint a judge, I would want to look for a person, first of all, who does have experience, legal experience, at least 12 years. That seems to be the standard that's appropriate because you're going to be in charge of a courtroom. So that experience in being in a courtroom is important. But in my experience as a lawyer, 43 years, lawyer and judge, that there are 90% of the cases where the outcome of the case is going to be the same no matter who the judge is. But there are some cases where the outcome of the case is going to depend on how the judge sees things and that judge's perspective. And I'm looking for someone who has integrity, honesty, and perspective, who's able to look at the case, who's able to consider both sides. And that's really the critical thing because, as I state, 90% of the time you gotta get the same outcome. It doesn't matter who the judge is, but you need a person with honesty, integrity, perspective. You are not guilty on a criminal case. That's the end of the case. You have to have someone there who has integrity, who has honesty, and who has a perspective and willingness to hear the whole case before you make a decision and make up the mind. and I will have a committee to review those arguments.
Very good. The next question just deals with your judicial philosophy for, interpreting Illinois Constitution or a statutory text, right? There's lots of different types of judicial philosophies that we read about in law school, whether it's textualism, originalism, pragmatism. When you were faced with two varying competing arguments about the meaning of constitutional or statutory text, what's your judicial philosophy in trying to resolve that disagreement, Justice House?
When I look at a statute and there's that kind of issue, I try to understand what exactly the legislature intended to, what they were intended to legislate, exactly what was going to be the outcome that they were trying to get to. And when I look at it, I try to see, is the law being applied to this fact situation the way the legislature intended? And that's basically what I'm looking at. I'm trying to put that into effect, what the legislature tried to do. That's basically what I'll give you.
Thank you. Mr. Krisloff, what would be your judicial philosophy in sort of resolving disputes about statutory constitutional text?
People have lawyers commonly have either two minds about this. They're either strict constructionists or the living Constitution. There are parts of the Constitution that say very plainly, like pensions should not be reduced. There are other parts that due process over time is very important, but due process doesn't define itself except by experience over time, and our due process rights have expanded. I wrote an article many years ago called "Where Are All the Strict Constructionists When We Need Them?" which was about judges interpreting the Consumer Protection, the Consumer Fraud Act, in a way that sliced off most of the protections and put in limitations. I believe that the law should reflect what the legislators intended, but I think once you vary greatly from the language, you are starting down the road to say what anybody thinks the legislature really intended despite the English language that they used. And so I think there's a balance, and I think you got to find in each case the balance between those two and get it right without just a label.
Justice Reyes.
I'm not guided by any particular philosophy. I think first and foremost, it's the question of, what does justice require? So that's what I look at in terms of the statute that I'm asked to apply to the particular facts and the evidence and the decision I'm making. And I look at the intent of the law, but I'm not guided by one particular philosophy. Say, well, this has got to fit into this cup. If it doesn't fit in there, then I'm not going to follow what my colleagues are suggesting. I think it's very important to look at the case and make a determination based on what's in front of you, and then make that determination. Once you've reviewed the statute or the law that's being asked to be applied.
Do dictionary definitions ever factor in? I mean, just the plain meaning of what the words say on the page?
Well, I believe in thoroughly researching every aspect of a statute. If it's applying the statute and look at the dictionary, but I don't necessarily feel that I'm going to be guided by the dictionary. Whoever wrote the dictionary wasn't in the chamber when the legislature passed the legislation. So I look at all aspects of it to make sure that I'm making a very well-informed decision.
Okay, Justice Cobbs.
So I want to address it just a little differently. I think I would like to address it in the context of an interpretation of constitutional protections. When I was a senior judicial law clerk at the Supreme Court level, we would frequently get questions with respect to Fourth, Fifth, Sixth Amendment rights. And the question would always rise as to whether or not the Supreme Court of Illinois would follow in lockstep the U.S. Constitution, or whether we would read the Illinois Constitution to be more broadly protective of an individual rights. So I think that what I would do is remember that the U.S. Constitution is a floor, not a ceiling. And to the extent that an individual defendant's rights were infringed, or if we read the Constitution too narrowly, it might be result in a harsh result. I would tend not to follow the U.S. Constitution, but to read the Illinois Constitution more broadly. A case specifically is People versus McCauley, where we had a youthful defendant who was being held in detention. His parents had called for an attorney. The law enforcement agents continued to query this young man without telling him that law enforcement was outside the door. Under the U.S. Constitution, that might have been permissible. We read the Illinois Constitution more broadly to require that whenever a criminal defendant is detained, he or she has the right to know that legal counsel is just outside the door.
Would you also read the right to bear arms more broadly then in that same vein?
It would depend really on what the nature of the issue was, and we also have to be practical in our interpretation of the Constitution as well.
Okay, Justice McBride, how do you resolve, the issues involving competing statutory or constitutional text? What's the philosophy?
Well, I don't have a judicial philosophy when we're talking about statutory construction or the construction of the Constitution. There's rules that are in place generally. I'm just going to use statutory construction. If there's a piece of legislation that's before the court, we're supposed to always first look at the language. And if the language is clear, we're supposed to effectuate that language. If the language is ambiguous, then we can go to other methods to look at what the legislature meant. Usually we just try to look and see what they said. If we can clearly interpret it, we're supposed to enforce it. If it's ambiguous, we can look to the legislative history. We can go into the legislative debates and see what did they mean when they came up with this law. Earlier, you talked about dictionary definitions. When a statute doesn't have a definition of a particular word or phrase or element, say in an offense, we can look to the dictionary for a definition, and we occasionally use that. So, I don't have a philosophy. I know there's rules for every single case, and if I'm given a specific issue, I would, start from the basic principles that we have to follow.
Okay. Justice Novell?
Yes, the Supreme Court is always presented with questions of statutory construction, and I think my colleagues have correctly stated those rules. You have to read the words and then you try to determine the intent of the legislature. But I would say that my judicial philosophy is a combination of being a strict constructionist and also believing at the same time that the Constitution is a living Constitution. I think the best example of that is the People versus Van Dyke case. I was the only person on the Supreme Court to dissent. I think that case presented a real question. It involved whether or not the Attorney General was entitled to a petition for writ of mandamus. I was somewhat concerned about the case because there was precedent. We have a system of stare decisis. And in my view, the Supreme Court was not following People versus Lee. So at the end of the day, I believe the court should decide cases and play by one set of rules. I didn't think that occurred in the Van Dyke case, and that's why I dissented.
Mr. Epstein, what kind of judicial principles would you bring to bear on interpretation of constitutional or statutory text?
Yeah. So I'd follow the law as is the requirement. But the difficult part is not just reading the words and trying to figure out what they mean. It's what happens when there's a conflict, right, between two different laws. What happens when there's silence? What do you read into the silence, right? And if you take that approach in a robotic way, I think you fail to realize that these laws were written by humans. And sometimes if you read the law and it seems robotic or unbearably harsh, maybe that should be a signal that we need to look a little bit harder, look for the humanity in laws, because it's there if you look hard enough generally. So we need to follow the law. But when it comes to conflicts, sometimes it's really important to do enough research to actually find where the humanity lives in the laws, because it was written by people, right? And so that's my approach.
Okay, now I've got a few questions for individual candidates. And then when we get done with that, we'll go ahead with closing statements. So we'll start with Justice Cobbs. What do you consider to be your most significant decision as an Illinois appellate court justice, and explain why? A couple minutes.
So you might find interesting that I find my most significant opinion in the Illinois appellate court one in which the Supreme Court reversed me. It is People versus Eugene Wright. In that case, a criminal defendant was admonished with respect to the right to counsel. That admonishment requires that the trial judge give to the defendant who is seeking to waive the period of time at risk for serving a term in imprisonment. In this particular case, this criminal defendant had been admonished 3 times by 3 different judges about a different sentencing range. He ultimately waived his right to counsel, was convicted, and received what was the statutorily permitted range. The case was appealed to the Illinois Supreme Court. The Supreme Court determined that the judge had substantially complied with the admonishments. In my view, the question wasn't whether the judge substantially complied, but instead whether the waiver of the right to counsel was knowing, when in fact there had been 3 different judges who had given this same defendant 3 different sentencing ranges. So I still believe that the appellate court was right in that case, and that the Supreme Court perhaps misunderstood.
That must be it. So next, Justice Reyes, I'm going to ask you a question about cash bail. What are the most important factors that need to be considered in determining cash bail, and what reforms could courts, if any, what reforms need to be made to cash bail systems?
Well, I think number one, you have to look at, I'm sorry. Of course, number one, you have to look at the offense that is alleged to have been committed. Number 2, you have to look at the individual's background and ability to return back after the matter is called again. I think those are 2 of the more important factors. In terms of reform, I think one of the things that we have to look at it is it's on a case-by-case basis. I don't think that necessarily it should be bright line across and they say, these type of offenses, person should be given cash bail, and these other type of offenses, they shouldn't be given cash bail. I think it should be on a case-by-case basis, and I think it should be allowed, it should be permitted for the judge to exercise discretion in terms of whether or not cash bail should be granted.
Okay, should ability to pay ever factor into cash bail?
Yes, definitely. Yeah, the ability to make sure that you could post the bail would definitely be a factor. Yes. Justice House, President Trump has often criticized federal judges who issue rulings that he doesn't favor. What should the court do when its legitimacy is questioned by outside groups or even politicians such as President of the United States? What should the judges do?
Well, unfortunately, judges can't comment on any cases that are.
Unfortunately, judges cannot comment on any cases that are pending before them, but there are groups who do defend the judges. The bar associations, for example, have come out frequently when judges are unfairly criticized. But all we can do is explain how we reached the decision, and we can't go any further as far as just addressing the comments from the peanut gallery, unfortunately.
Okay. Do you think that there's, without sort of defending a particular decision, is there even any scope for judges to just discuss generally criticisms about independence, or do you think that's inappropriate?
Let me understand your question, please.
Sure. It probably wasn't the best question. I guess the question is whether judges should or could speak out about politicians criticizing the independence of the entity itself.
I think that once our jobs are to hear the cases that come before us, to apply the law to the case, and to make a decision. I think once we vary off and get into the political thing, it kind of takes us off the mark about what we should be doing, and we just have to rely on the bar associations and the other groups that try to protect the court to do their job.
Very good, thank you. Mr. Krislov, do you think that the courts should pass more rules to reduce the cost of discovery on parties in civil cases? There's oftentimes a lot of articles written about the extreme cost of certain electronic discovery. If you think that there's any changes that could be made to reduce the cost of discovery, what would you suggest?
I've got to think about that for a second. I think that a judge can, and this is trial court judges, can focus and should. One of the problems that we run into in cases is that people on one side often have such large resources and pursue such discovery that can be either intimidating against a small, certainly a non-represented plaintiff. At the same time, the trial judge can rein the case in a way that, and I'd often thought about suggesting this as in every case. Here's the case, here's what it's about, here's the critical issues that we need to deal with. Let's just do the discovery on those, rather than having this be a battle of resources. It's important to preserve the resources of the court and the parties and to get to justice as fast as possible. So I think in that respect, a rule that says that the trial court judge should get involved, rein in the discovery, and do the discovery that needs to be done. I think that actually, whether it's electronic discovery, which in higher level litigation among corporate people is just terrific. They love to spend the money. But where you have a difference in resources, cutting, and frankly in those big cases too, cutting to the nub of the thing rather than having us dragged out for years in discovery would make a lot of sense. And that I think the trial judge can do.
Mr. Epstein, what do you say to possible critics who say 4 years as a lawyer, just not long enough, not enough experience to be an Illinois Supreme Court justice?
Yeah. So I'm proud of my experience. I've served clients in the Supreme Court of the United States in more than a dozen jurisdictions across the country. I've done appeals, post-convictions, criminal defense, civil rights, immigration, domestic violence, orders of protection. That was all the pro bono side. The other side, complex commercial civil litigation, antitrust, intellectual property, and on and on. Government contracts, internal investigations, etc. Published influential pieces of scholarship. I'm proud of my service. But I'll say this as well, which is vision is a qualification, an important one, especially because the Illinois Supreme Court is a policy-making body. It's a policy-making body. We need to propose policies. That's what I'm about. That's what I've done. I'm the guy with the vision. That's a qualification.
Very good, thank you. Justice Neville, there has been newspaper articles written about this homeowners exemption issue. But what do you have to say to the critics who might say, you should have been more careful in, doing the taxes on the house? Just what's your take?
I would say it's a non-issue. Here's why. My parents bought 4320 South Vincennes in 1959. When they acquired that house, a homestead exemption is given to an owner who has an ownership interest and considers that to be his principal residence. My father died in 1992 intestate. My mother took over the property. My mother lived there from 1962 until 1991. That was my principal residence during that entire time. My mother died in 1991 intestate. I have a brother and 4 sisters. We all acquired a 1/6 interest in the property. It was my principal residence from 1991 until 2011 when we moved so that we could rehab the house because I planned to make it a landmark since I'm the second African American to sit on the Illinois Supreme Court. It's a non-issue. I didn't need my mother's homestead exemption because it was my principal residence. I had a 1/6 interest. I think that's an issue that's been raised by my political opponents. It is a non-issue.
Thank you.
And finally, I paid for the time that I did not live there. It is just a non-issue.
Thank you. Justice McBride, what, if you were elected to be the Illinois Supreme Court Justice, what is one life experience, primary life experience that would be most impactful in your approach to being a Supreme Court Justice?
Well, I've seen a lot in my lifetime, and I grew up in a large family. My father died when he was very young. My mother went back to work to raise 7 children. I realized very early on what's important in this world, not the cars we drive around in or the clothes we wear, but people, and making sure that we treat people with dignity and respect. There were two things I got from my mother and father. One was that old golden rule, treat people the way you want to be treated. I have made a lot of friends in the last, 67 years of my life. But treating people fairly and with respect is something that, is a part of me. The other part of me is that, my mother was someone who said, don't ever give up. Don't ever give up. And, I think people should fight for what they believe in. I think if you have goals in your life, you should pursue them. I think you should encourage other people to pursue their goals. And I think that, respect and dignity are probably the most important factors that a judge should have. And I think that justice is something that we have to deal with every single day. I've been involved in the administration of justice for 43 years. A traffic case to one person where they're charged with speeding is really important. I've heard hundreds of traffic cases. I've heard criminal cases. I've heard multi-million-dollar lawsuits. Every single case to those people and those parties. And then the person who's suing their neighbor because they had a fight over something. All those cases are really important to those people. No matter what case it is, it should be decided based on the facts and the law and fairly. And you know what? The symbol of justice is a woman who has a blindfold over her eyes and she's got a sword in one hand. But the point is that when we decide cases, we're not really supposed to be looking at we're not supposed to be deciding cases on what that person looks like or who they love or whether they believe in God or they don't. And the sword represents the enormous power that judges have. And to be a judge is a privilege. It's not a right. And you're serving the public. And so I believe that that's the most important part of the job, that we work for everyone and we have to make sure that the administration of justice is for every single citizen. It's not for a group and it's not for an individual. It's for everyone.
Okay.
And I think that's what I represent.
Let's move on to closing statements. We'll start off with Mr. Epstein.
Thank you so much, and thank you again to everyone who attended.
2 minutes, please.
Yeah. So I talk a lot about ideas in my campaign, about reforming our system, reforming our justice system. But this isn't just abstract ideas for me. It's not just rules. It's not just concepts. They're anchored in people that I represented, people who I felt were harmed in preventable ways. And I think that's really important to remember, that these rules and these procedures that we talk about can sometimes seem abstract, but they are human. And there are humans who are sometimes out of sight and out of mind for us, but are affected by these issues in deep ways. So this is a human thing for me. But I'll also say that I'm optimistic about our chances of repairing our system. And I'm optimistic for a strange reason. There's a Japanese art called kintsugi, where it's an art of bowl making. And you take these ceramic bowls that have broken along these long lines, and there are multiple different ways you can repair these bowls. One of the ways is you can put them back together with clear glue and pretend that they were never broken. But that's not what kintsugi artists do. Instead, they mend them using precious metals, so that rather than ignore the cracks and the history of breakage, they become part of the history of the bowl itself. Not something to ignore, but actually, as precious metals, the most beautiful part of the bowl. Kintsugi artists make the repair the most beautiful thing about it. That's how I want to approach this. It's okay that we have room to grow in our justice system and room to improve. Let's do that. Let's repair it, and let's make the repair the most beautiful thing about it.
Let me conclude by first complimenting our moderator.
Thank you.
Promise to do.
It's not necessary.
Having said that, Martin Luther King said that the moral arc of the universe bends towards justice. My moral arc is governed by the Equal Protection Clause of the 14th Amendment. King also said that the true measure of a man is not how he behaves in moments of comfort and convenience, but how he stands in times of controversy and challenges. The Van Dyke case was one such case. He also said that cowardice asked the question, is it safe? He said expedience asked the question, is it politically correct? He said vanity asked the question, is it popular? But conscience asked the question, is it right? Ladies and gentlemen, I submit that there comes a time when a judge must take a position that is neither safe, nor politically correct, nor popular. As a judge, I take the positions that I believe are right. I believe, like Thurgood Marshall, that a judge should do what is right and let the law catch up with it. I plan to serve the citizens of Illinois by doing what I think is right, and I will let the law catch up with my decisions. Thank you.
Justice McBride.
Well, I want to thank everyone that's here today, and I want to thank all of my colleagues. And there's a lot of hardworking people in this room. And I don't really take the view that the system is broken. I think it always needs improvement. But I took up a lot of the time already, just moments ago, explaining who I am and why I'm running for the Illinois Supreme Court. And I think that the system works, but I think it works if we have good, hardworking, honest, decent people that are willing to put in a full day, and that our court system should be for everyone. I want to compliment everyone that's here, the moderators, the sponsors, everyone that's sitting here. And I work with everybody. I have worked with a number of people here, and I appreciate and respect my colleagues. And I thank all of you for letting us have the opportunity to talk to you today, to tell you who we are, what we represent. And thank you for giving me the opportunity.
I echo my colleagues in this campaign's sentiments with respect to thanking all of you and expressing appreciation for your time and your listening ears here this evening. I, having been the state court administrator working with the Supreme Court in its role, its constitutional mandate to oversee the court system, take a little bit of a disagreement with Mr. Epstein. I don't believe that our court system is broken. For the 9.5 years that I served as director, I spent much of that time collaborating with the 7 justices of the Supreme Court to ensure that the administration of justice improved and was enhanced year after year after year. The Supreme Court has 2 major functions. One is to dispose of a percentage of cases that they accept on appeal. The other is to administer the court system. I have been the director of the Illinois courts, the chief legal counsel for the Supreme Court's administrative office, senior attorney, a circuit court judge, an appellate court judge, a senior judicial law clerk, and an appellate court law clerk as well. I've seen the court system inside and out. I know that there are improvements to be made, and I applaud the Supreme Court currently for seeking to make those improvements by impaneling a commission on access to justice, by creating a judicial college, which I am privileged to serve as one of 6 trustees, working with our justice partners to make certain that those who come into our justice system receive competent and fair representation and information. And so I am running for the Supreme Court of Illinois because I have the knowledge, the competence, the experience to bring to that court those initiatives and those ideas, those ideals that are necessary to ensure that the justice system here in Illinois continues to operate fairly and efficiently for all of the citizens of the state of Illinois, and in this Cook County seat, particularly for the residents of the county of Cook.
Justice Reyes?
I also want to thank our sponsors, our moderator, and those of you who are in attendance here in the room, and my fellow panelists also for being here and taking the time. I think it's important for us to put on our credentials so everybody who goes to the polling place on March 17th will be well informed in terms of who we all are, in terms of who are you going to vote for. And as I stated before, I've had the opportunity to serve as an associate judge, a circuit court judge, and as an appellate court judge. Each time I have been found to be qualified or highly qualified for each of those positions. Currently, I was found highly qualified by the Chicago Bar Association to be on the Illinois Supreme Court. And as I mentioned before, I am not just a person that gives back to the public while on the bench wearing the robe, but I am someone who works off the bench for the public. I truly believe that I am a public servant for the people 24/7, and that's what I'm going to bring to the Illinois Supreme Court. And as I mentioned earlier, I'm also a true believer. If you see something that needs to be fixed, you fix it. You just don't complain about it and talk about it. It needs to get done. You do it. Thank you very much.
Mr. Kristoff?
Thank you all for coming. Thank you all for being here. It's been a pleasure. You don't want to hear the thank yous. You want to hear information. Our system needs the input from people who have been in it, who are fighting through it. Being on the appellate court is an isolating experience because years ago when Justice Greiman first joined, and he had previously been on the floor of the Illinois Senate, and he said, I used to talk with 150 people a day. Now I just issue a memo every month to the other members of my division as to where we're going to have lunch next week. I think that although all of my colleagues here who are on the bench are certainly trying to do the best job possible, we need to have input from the people who are actually in the battle. And that on the Supreme Court is missing, and that would be an improvement. I spent 40 years doing this practice up against the big guys, is what the Tribune called my practice years ago. I've done this before most of the federal circuits, a number of district courts throughout the country, half a dozen state Supreme Courts. I've done the battle, and I've gotten an experience of how tough it is. And I want to make that battle more even, transparent. And I think we need somebody who's been in the battle on the Supreme Court, and I hope you'll agree with me. And I hope they post this on a website somewhere so that everybody can make this evaluation. So maybe before you sign off, you should let us all know where to find it on the website.
You'll know as soon as I know.
Good evening again. I want to thank the sponsors for giving us the opportunity to present ourselves and our credentials and let people know what we're about. When I come to the Supreme Court, I'm going to bring the values of honesty and integrity that were instilled in me. And I will also bring to the Supreme Court a perspective that has experienced injustice and the unequal application of law. I can remember being in Tennessee and having to go to the movie and having to sit in the balcony and not being, by law, not allowed to sit on the first floor of the movie theater. So I understand how that feels. It's a very disheartening feeling. Legally, you were not allowed to do it. And I remember that feeling, and that feeling is giving me a drive to seek justice. And that's what I'm doing with my career. I'm seeking justice. The struggles that my family experienced in Tennessee as underdogs are very much reality for many families today. And as your next Supreme Court justice, I will fight every day for those families who experience that type of injustice. I promise the voters of Illinois that I work as hard as I can every day, both as a candidate and as a Supreme Court justice on behalf of underdogs everywhere. So if you believe that a person with my perspective belongs on the Supreme Court, a person who's sensitive to the right of everyone to be heard. I ask you to remember 5 little words on March 17, 2020. House is in the house. Thank you.
Give everyone a round of everybody could give a round of applause to our candidates. We really appreciate your time.